We also have the honor of having Professor Luke as our first conference speaker today. He will speak on the topic, Career Preparation and Opportunities for Science and Engineering Students to Pursue a Career Path as an IP Attorney. Once again, let's everyone welcome Professor Luke.
I will introduce what is going on now in Hong Kong for the IP industry. We have the patent reform, and the patent system is undergoing a change. First, I will give you some of my basic background. I'm a lawyer, and as many people will know that lawyers do play a very important part in many of the IP disputes. But at the same time, I'm also an engineer. So that brings me the benefit of understanding both the legal and the engineering side. MIE stands for the Manufacturing and Industrial Engineering, and that is my discipline. So I'm also a senior member of the Institute of Industrial Engineers, now known as the Institute of Industrial and System Engineers. My professorship is from the Hong Kong Polytechnic University, the Department of Industrial and System Engineering. And of course, I also hold various other positions in different universities. I was lucky to be appointed among the first group of arbitrators by the Hong Kong International Arbitration Center recently into the panel of Hong Kong IP dispute resolution. For quite a number of years, I'm the panelist of the domain name dispute resolution. And on an average, I adjudicated about 1 case per month. And that is pretty high in terms of this kind of dispute resolutions. And I'm also a member of the Hong Kong government working group of IP trading. And this working group set all the strategic plans about the development of IP industry in Hong Kong. Okay, first I will introduce some of our training programs. And I was fortunate to see quite a number of our former students here. They have joined our program, and I believe they also enjoy the program quite a lot. Our Level 1 program introduced the basic knowledge in IP law and practice. And the program, we cooperate with the Hong Kong Productivity Council. And maybe that is one of the reasons why a number of City University staffs and students, they are interested to join. And I still remember that one of the students, I don't see her here, and she helped us to bring us to the restaurants for the lunch coming to the City University. And of course, you can see that basically we cover many areas of the intellectual property law. And of course, it was taught by many different professionals from different jurisdictions in order to cover this area. We have the Level 2, which is a program that in cooperation with the University of Warwick in the United Kingdom. It will lead to a postgraduate award. And this postgraduate award can actually credit to their master program. So students, after completion of this course, has the option to proceed to a master program with credits. So it will cover the international patent fundamentals, the patent drafting, and also the product design and development. We call the Hong Kong IPA version, because this course different from the ordinary product design course, because it will emphasize the importance of intellectual property protection right at the very beginning of idea stage. The Level 3, we are still discussing with a number of institutions. And the purpose of the Level 3 is to prepare the candidates to sit for the national exam of the Chinese patent attorney qualifications. So it will cover all the 3 modules that to be examined. And it includes the related legal knowledge, the patent legal knowledge, as well as the patent agency practice. As I say, the purpose of the course is to prepare the candidates to take the exams. And after passing the exam, the candidates is required to complete a 12-month training. And currently, this training part is quite difficult. And our association is planning to visit Beijing and talk with the All China Patent Attorney Association regarding whether the training can be conducted within Hong Kong. And actually, legally, it is possible. They already have the policy set out how to conduct the training, but practically, it's still not being done. So we hope that we can break through this. And of course, after the training, and if you are connected or practice with a patent attorney firm, then you are a licensed Chinese patent attorney. Of course, these are the different levels of the Chinese patent attorneys, but the name, especially the English name, has not been confirmed yet, because one of our branch association, which I will introduce later, and maybe Ms. Yip will talk more about that, because she is a council member of that association, is the Hong Kong Chinese Patent Attorneys Associations. They will define what are the proper terms to call, but that is just the temporary terms to be used. Once you pass exam, currently most people will put it on their name card, a qualified Chinese patent attorney. And of course, if you got a practicing license, then you are a licensed Chinese patent attorney. And some of the more senior patent attorney, they will be recognized by the Supreme People's Court to be the licensed Chinese patent litigator. And actually, they can represent clients in the patent court. We have listed out some exemptions. Not all the people, they need to take the level 1 courses. Okay, we have a short review about what are the development and the history of our patent system. Before 1997, if we want to obtain a patent, we first need to obtain a patent in UK or the European Patent Office designating UK. And then we'll register that patent within 5 years after the grant. And of course, after 1997, there is a review that what should be the new law in Hong Kong. Unfortunately, I will use the word unfortunately because that is a time where we can bring in reform in Hong Kong, but they still, after discussion, they still decided to retain the old systems, and they just add in one more recognized jurisdiction, which is the Beijing State Intellectual Property Office. We have 2 kinds of patents in Hong Kong. And the standard patent is based on the free registration, the registration in free of the designated patent office. And as I say, it adds the state SIPO, we call the State Intellectual Property Office. Like many other jurisdictions, we offer the protection period of 20 years. Superficially, the government always said this is a very simple procedure. It only involves 2 steps. But many of our council members would like to call it, actually, it is a 4 stages procedure. First, you need to file a request to record the patent in Hong Kong after the publication. That means the first step is you file the application in one of the 3 designated patent office, UK, Europe, or in the Beijing. Then you need to file a request to record in the Hong Kong Intellectual Property Department. And after a number of years of struggling back and forth, we call the office actions, then finally you may get the grant. And after you get the grant, you need to file a request for registration. So this is actually talking about 4 stages. And the Hong Kong Patent Registry only conduct a formality examination. What is formality examination? That means they can check that all the documents are correct, all the dates are correct, all the names are correct, and all the papers are in the right order. But they do not conduct the substantive examination, which is involving, they were assessing the patentability of an application. This is what is lacking now in Hong Kong. And we also have the short-term patents. It offers a shorter period of protection, but at the same time, it also offers less protection as compared with a standard patents. Of course, as I say, currently in Hong Kong, we don't have any substantive examination in place. So they don't conduct, the registry do not conduct a substantive examination. You only need to file a search report from a recognized international searching authority. Then you can file the application, and they just conduct the formality examination, and you can get a short-term patent in Hong Kong in as short as 3 months or just a few months' time, you can get it. And they have the restriction, it's only limited to 1 independent claim per application. However, if you want to use this short-term patent for enforcement, for IP protection, we talk about the burden of proof, the onus to proving you have the patentability and the validity of the short-term patent. That means when you are going to bring an action in court, then the owner needs to prove the validity of his patent. Don't forget that the patent has not gone through the substantive examination. So many unknown factors, and the patent may be defeated on the validity side in the court. And of course, there are also remedies against groundless threats of infringement proceedings, and that will stop many owners from enforcing their rights. And of course, option is also available for any person. Please remember they use the word any person to initiate proceeding in court to revoke a granted short-term patent. And of course, in the mainland China, we have a similar system, but not exactly the same. The difference, maybe I will leave it to Ms. Yip to explain what is a utility models in China. Okay, what is the situation of patent agency services? There are some common wordings. Sometimes in some jurisdiction, they refer as patent agent, and some jurisdiction refer as patent attorney. Patent attorney is not means lawyer, okay? That is a very, very important concept. Patent attorney does not mean that one is a lawyer, okay? Patent attorney and patent agent actually means the same thing, but different jurisdictions use different terms. And our new patent amendment bills will propose to protect both terms. That means even Hong Kong, we have not decided which term we will use, but both names will be protected. And their duty is to help the clients to prosecute, not to sue, okay? This is a industry word we call prosecuting an application for patent, not suing others, okay? And of course, the scope of the work, first, I have referred to the patentability. The patent attorney or patent agent need to assess whether an application they have the necessary patentability. And of course, drafting is a very important skill. Why I said that this is an opportunity for the science, technology, and engineering graduates, because in terms of drafting, you need this kind of technical knowledge in order to be able to conduct a good drafting of the claims and specification. I remember one of the, I would say, experts in the IP valuation. He said that actually for the same patent, if your drafting is good, if the scope of your claims are wide enough, that means it is not only protecting the patent itself, but it also protecting other people from entering into similar products in competition with you. That is a very well protected and good drafted claims, okay? That will have a higher value than an ordinary or badly drafted claims. So you can see that it's not only obtaining a patent protection, but a good drafting. And of course, responding is, as I say, that the office action. Very often, it is very seldom that when you file a patent application and then right to the end, you will obtain your patents without any questions. Usually, there will come back some questions or even objections coming from the examiners. So how to respond to the examiners is also a technical skill. We call this kind of office actions. So all these require technical knowledge. That's why a technical background graduates will have the advantage. And also, it is actually a requirement for you to have a technical degree before you can attempt the National Patent Attorney exam of China. So, but their definition of technical degree is pretty wide. So, for example, a psychology degree is being recognized as a technical degree. So, but in actual practice, of course, I will advocate a science, engineering, and technology degree is better. Okay, we have talked about the Patents Amendments Bill. Now is on the electrical, and it is among one of the bills that has been put on the priority list. That means hopefully it can be passed before July. But with the current backlog in the passing of the bills, we are just worried that whether these patent amendment bills can go through within this session of the electrical. Unfortunately, if it cannot go through, it's not just talking about waiting for the next section, but they need to start the procedure all over again. That means gone through the first reading, second reading, the bills committee stage. Now they already passed through all these stages, okay? But anyway, more importantly, I will highlight the section 144A, which are talking about the interim measures on the patent agency services. So it's important as from the enforcement of the law, if the bill is passed, a person cannot in the course of business, trade, or profession knowingly use a title of certified patent agent, registered patent agent, certified patent attorney, registered patent attorney, and more important under E, a description, a title or description, which may reasonably cause anyone to believe that the person using or permitted to use the title or description holds a qualification that is specifically granted for approving that person to provide patent agency services in Hong Kong, and that is recognized by law and endorsed by the government. So this is a very controversial section, and it's quite vague. That means it is actually quite possible that inadvertently, when you use certain titles that you may infringe the law. And we are talking about criminal penalty. I will come across that section later. So that is the unknown part. We have to be careful. And of course, they also provide an exception. Subsection 1 does not prohibit a person from using or from permitting the use of a title or description that is solely related to the person's qualification for lawfully providing patent agency services in a jurisdiction outside Hong Kong. So that's why currently, for our association, we will help many of our members to pass the Chinese patent attorney exam. Because once you pass the exam, you can describe yourself as a Chinese patent attorney and still able to practice the new original ground patent under the Hong Kong law. So that is what is provided here. And of course, the purpose is to protect the current foreign qualified patent attorney or patent agent. They can continue to practice, but they need to change the name. If you qualify in UK, you need to put UK patent attorney. If you qualify in Australia, you need to put in Australia or Australian patent attorney. So it's up to different jurisdictions how they should describe themselves. But the importance is, in order to fulfill this exception, that you must clearly indicate that the jurisdiction that you are qualified. Under subsection 4, that is the criminal provision, that a person who contravenes this subsection 1 commits an offense and is liable on a conviction to a fine of 500,000. It's not a small sum. So all the patent agents or patent attorneys needs to be aware about the new law. Okay, going back to our association. We are formed in 2009, and one of our main objectives is push for the reform of the current patent system. And in 2011, a public forum was, of course, before that we have done a lot of lobbying to the government and also to the LegCo members. So a public forum was held by the Intellectual Property Department to discuss whether there is a need to reform, and it was participated by 170 representatives from different sectors: legal, patent, R&D, academics, industrial. And in the same year, a consultation paper was published. It is called the Review of the Patent System in Hong Kong. In the same year, an advisory committee was appointed. The committee held a total of 6 meetings. And in 2012, December, a report was submitted by the committee. And 2013, the report was translated into a report of the advisory committee and was published. I still remember the day when the report was first announced, before even the media was known that various professional bodies or stakeholders were being invited to the intellectual property department, and they tried to explain about the purpose of the report. And one of the practitioners raised up the hands and asked, what is the policy of the government on this report? And the then director of Intellectual Property Department answered, this report represents the government policy. So it is very clear what was being said in the report represents the policy of the government. And of course, there are some key recommendations. The first and the most important recommendation is they are going to introduce original ground patent in Hong Kong. So, and of course, at the beginning, when we tried to lobbying the government of establishing the original ground patent, they said they have no money, no people, and they have no skills. Okay, So it cannot build Rome in one day. So we can say that, okay, Singapore is also like Hong Kong, a re-registration system, but 10 years ago, they reformed and bring in the original grant pattern. And at the beginning, they outsourced the most difficult part, which is the substantive examination, to some other patent office. So we talked to the government, said you can do the same. So finally, they decided the outsource will be to the Beijing State IP Office. And that is the reason why, although the law did not clearly indicate what will be required in future to be qualified as a Hong Kong patent attorney, but in actual practice, since the substantive examination will be done by the Beijing State IP Office, so it is beneficial for the practitioner to pass and understand the requirement of the Chinese patent attorney. So we have chosen that path. And of course, one funny thing about is also to balance the interests of all parties, because some people are opposing this idea. The current re-registration system will still be retained. So we don't know, which side will be prevail. And of course, they also decided to retain the short-term patent, but they understand there are shortfalls about the system, so they bring in some refinement. So now, before you start a proceeding, infringement proceedings, you can request a substantive examination. The benefit is it shifts the burden of proof. That means when your patent has been substantively examined, then that means it is a patentable and valid patent, at least in the eyes of the patent examiners. So it's up to the defendant to disapprove you, to raise the point that your patent is actually invalid. Otherwise, then you have the benefit of the burden of proof. And of course, there are some other reforms. Two major parts is you can have the substantive examination before the proceeding, and the other part I understand is you can have more than one independent claims per application, and that is important. Okay, but the patentability criteria will remain the same. Okay, that is the controversial part. Under the report, it said a full-fledged regulatory regime on patent agency service, which involve both the provision of services and the use of professional titles, should be set as the ultimate goal in the long run. And then it talked about interim measures to be developed with regard to the existing patent agency services, and maybe certain grandfather provisions should be brought in to have the recognition of a regulated patent agency professions. At that time, we have submitted a pretty long, actually you can still see our submission in the Intellectual Property Department website, a pretty long submission. We take the example about the Chinese medical practitioners as an example, how they gradually bring in the grandfather clause and at the same time set for the new standard and new requirement. But that was not being adopted. And as you can see from the bill, that they only regulate the use of professional titles. And the regulation is not who can use. They just said that everybody cannot use, okay? Everybody cannot use the titles. And the only exception is if you are foreignly qualified. It doesn't matter which jurisdiction you are coming from, as long as you put in the jurisdiction to describe your qualification. And there's no grandfather or recognition about existing practitioners. So, for example, for lawyers, they used to describe themselves as agent for patents. But I believe after the bill, Lawyers cannot use that description anymore. And representatives of the Law Society are among the working group, but they never raised this point. So that is, I would say, the funny part, and we need to see what are the results. Okay, and they have issued a consultation, as I say, that our submission is on 2013, May 30. Everybody is welcome to have a look on our long response letter. Okay, and in the 2013 Chief Executive Policy Address, he talked about setting up a working group. And of course, the working group has been set up in April the 2nd. I don't know whether it is a coincidence, but on April the 1st, which we usually know as the April Fool Day, that the Singapore government issued a report by the Ministry of Law on how to bring Singapore into the IP hub of Asia. And it is a 10-year strategic plan. They announced a 10-year strategic plan with substantial commitment and also capital being injected by the government. So one example is for IP finance. They will support the IP finance with back-to-back guarantee by the government. But in Hong Kong, we don't have this benefit. And of course, we see that at the consultation stage, we see that we must have some kind of consensus among different professional bodies. So we call a joint meeting about the patent practitioners, which include 4 professional bodies: the Asian Patent Attorney Association Hong Kong Group, the Law Society, our association, and another group which mainly represent the interests of foreign qualified patent practitioner, which is called the Hong Kong Institute of Patent Practitioners. In 2014, we are the first group representing the patent practitioners to have a delegation to Beijing. And we visit the SIPO. We also visit the All China Patent Attorney Association. And we are planning the second delegation in this year. And of course, we have 2 meetings for the, these are privately organized meetings. And then, of course, what happened is we have been invited by the Hong Kong International Arbitration Center to submit names about recommended IP experts. And we submit a list of about 20 experts. Unfortunately, and I would say unfortunately, I'm the only one that being selected. And among the published list, only 13 people from Hong Kong are among the list. And out of these 13 people, majority of them are retired judges, very famous senior counsels, and this group of people will never come out to act as arbitrators because of their status and their busy schedule. And then left, just a few people can actually come out to practice, and the rest of it are international experts. Okay, and then now the government realized there's something need to be done, and of course the government has their agenda. They already have in mind what they plan to do, like what has been said in the bill. So they invite the 4 professional bodies, and they add in 2 others. So now we are talking about 6 professional bodies. Here are the lists. So they added the Hong Kong Bar Association, as well as the Hong Kong Institute of Trademark Practitioners to the group. And for all the 6 professional bodies to join in the discussion about how to regulate the Hong Kong patent practitioners. And of course, we have various meetings and talking about some proposal, not only on the regulation, but about the detailed procedure and some of the provisions inside the bill. And of course, the important thing is 2015, Since more and more of our members, I would say it's approaching 50%. I don't know, Liz, whether you agree. It's approaching 50% of our members are now Chinese qualified patent attorneys. So a branch association was being formed in 2015, January. The Hong Kong Chinese Patent Attorneys Association was formed, and it has been informed to the All China Patent Attorney Association. That means they know about the existence of this group. And of course, we also have the interest group like the UK Patent Attorney Group, the US Patent Attorney Group, the Australian Patent Attorney Group. We still have, but they are relatively small. Each of this group consists of less than 10 people. After all, currently, the practitioner, the number of practitioners in Hong Kong is still not too many. But for you guys, all of you sitting here, these offers opportunities. So these are all my presentations, and I hope that it will not bore you too much. So I will leave it to our other speakers. Thank you.